Okay, good afternoon, everyone. We are live now. Happy New Year to everyone. It's wonderful to see all of your faces. I wish we were together, but this is going to be a preview of what session will look like in a couple of weeks. And obviously, we've been here before, so thank you for adapting to this format. Before I turn it over to Senator Hettleman, I just want to thank all the participants from earlier in the summer last year for all the work you did on the committee, and then also for this hearing as well, and the information you provided. I think they were instructive and helped form those recommendations, and will inform a lot of our work in just a few short weeks here. And in particular, I want to thank Senator Hettleman for her leadership and stewardship, because this was I thought it was a fantastic report, and really well done and well researched, and it was just hats off to you for your work on this. So thank you very much, Senator Hettleman. Obviously, since the work group last convened, renters, mortgage holders, tenants, banks, we all operate in the same ecosystem, and all of our collective destinies are inextricably linked. And so today, the goal of today's presentation and briefing is to get an update as to where we are, a status check, and so we can gain some ground truth before we head into session. I think the information that we'll get here today will be instructive and will be helpful as we kind of refine some of the legislation that I'm sure some of you have seen on the MGA website that will be before us as we reconvene. So with that, I will turn this over to Senator Hettleman to introduce our panelists and to make a few remarks. So thank you very much. And Senator Hettleman, I'll turn it over to you. The floor is yours. I'm getting text messages from Senator Hettleman. Her Zoom just went out. So I'll go ahead and introduce the panelists. So today we have Chief Judge Morsi. We have Terry Hickey, who's the Deputy Director for Housing and Community Development, Baltimore County. Carissa Hatfield, the Homeless Persons Representation Project. Zafar Shah from the Public Justice Center. Aaron Greenfield and Adam Skolik from the Apartment of Office Building Association and Maryland Multi-Housing Association. We have Mr. Enton, Bob Enton, Ms. Lehman, and Ramon Luby from the Maryland Bankers Association. And Rory, I saw you over there, and John from the Maryland and the DC Credit Union Association. So we're going to go through in that order for our presentations, and we're going to hold our Q&A until the very end. So with that, I'll turn it over to Chief Judge Morsi. The floor is yours.
Thank you, Chair. Can you hear me?
We can.
Great. Good afternoon, Chairman Smith, Work Group Chair Hettleman, members of this work group and committee. I hope that all of you have had a very happy and safe holiday season. I'd also like to thank this committee and its work group for the hard work done and the efforts made on such important issues. The District Court of Maryland has exclusive jurisdiction over landlord-tenant matters in Maryland. There's 4 basic case types that are heard by the District Court with respect to landlord-tenant issues. Failure to pay rent cases, which are by overwhelming majority are the most common. And the issue in failure to pay rent cases is really limited at this time to whether the tenant has paid the rent due. There's some exceptions to that, but that's generally what that type of case is about. Breach of lease, where a landlord is claiming that a tenant is somehow in a substantial breach. It must be substantial breach that occurred in order to terminate the lease. A tenant holding over action, where the lease term is expired and the landlord no longer wants to lease to the tenant. And a wrongful detainer action, and that's where an individual who has no legal right is basically squatting in the property. And the landlord is or it's not even the landlord, whoever the owner of the property is requesting that that person be removed. Prior to the pandemic, the district court handled an average of 55,000 failure to pay rent cases each month. Beginning in March 2020, as the result of the pandemic, we started to alter our operations, and the number of failure to pay rent filings decreased markedly. In March, it went from 33,000. You're not quite, thanks, Heather, we're not quite there. In March, there were 33,000 instead of the normal expected 55,000. In April, it went down to 6,000 because that's when we really restricted our operations at that point, when the pandemic was just starting to really take off. In May, the number reduced to 3,700 approximately. In June, it went down again to about 2,100, a little less than 2,200. And then in July, it started to rise again as the court started to reopen and add more case capacity. So there were 6,801 filed in July. Then in August, 16,952. In September, a little over 30,000. October, 33,000. And then, as I'll describe in just a moment, we had to start to restrict operations again. And the number went back down in November to 24,000. Those are failure to pay rents. Again, the most common. And you'll see when I go to this next slide, Heather, if you would. Prior to the pandemic, the number of breach of lease filings averaged about 120 per month. From March 2020 through November 2020, the average has been 158, with the highest number of filings, 212, for these case types occurring in November. And you can see that on that graph that I just put out. I expect that to come back down as we restricted operations, most recently at the end of November. Prior to the pandemic, for the next slide, the number of tenant holding over filings averaged 200 per month. From March 2020 to November 2020, the average has been 285, with the highest number of filings, 552, for these case types occurring in October of this past year. And then to the next slide, prior to the pandemic, the number of wrongful detainer filings averaged 154 per month. From March 2020 through November 2020, the average has been 112, with the highest number of filings, 193, for these case types occurring in October. In the next slide, you'll see that prior to the pandemic, the number of evictions for fiscal year 17, 18, and 19 have kind of been very steady at approximately little over 22,000 per year statewide. In fiscal 20, you can see there were 15,472. And the reduction is almost certainly from the restrictions to court operations resulting from the pandemic. Because if you think March, April, and June would have made up that last quarter, had it not been for that, it probably would have been on track for another 22,000 evictions during fiscal 20. In July, you can see to the next slide, in July 2020, there were 75 evictions statewide. August saw 522 evictions. September, 653, and November, 511. The majority of these evictions are coming from months before, prior to the time that the court had to restrict operations in March. Whatever was on the books, we just kind of went with them moving forward, obviously subject to all the defenses that I'll talk about now. Since the beginning of the pandemic, the district court has made a number of changes to the landlord-tenant process in light of Chief Judge Barbera's administrative order regarding evictions, Governor Hogan's executive order regarding evictions, the CARES Act, and the CDC agency orders. Communications to guide and inform the judiciary and the public of how the court will procedurally handle landlord-tenant actions have been made frequently and are published on the judiciary's website. In fact, I just added one on December 30th as a result of the new appropriations bill and the extension of the CDC agency order until January 31st. In addition, the judiciary has been continuously updating its website to reflect additional information and guidance to both tenants and landlords as the situation warrants. Brochures and flyers containing revised and updated COVID-19 and housing information have been placed in the clerk's office. On July 8th, 2020, the district court sent a letter to all county executives requesting their assistance in providing information to the judiciary regarding rental assistance programs available to landlords and tenants in their respective counties. The district court has also been working collaboratively with the Secretary of Housing and Community Development to coordinate information regarding rental assistance programs. This information was forwarded to the judiciary self-help centers to incorporate into their knowledge base so that an appropriate resources could be provided to individuals seeking assistance. As you all may recall, that the self-help centers are staffed by trained legal aid attorneys and provide free civil legal advice. Timed to coincide with the expiration of the CARES Act in August, the district court began attaching stickers to the service copies of the failure to pay rent complaints, alerting tenants to the services provided by the self-help centers along with contact information. On October 1st, 2020, the failure to pay rent forms were permanently changed to include this language. From March 2020 to December 29th, 2020, the self-help centers have given free housing advice, including rental assistance availability to more than 18,000 individuals. There are more people that use the self-help centers, but those 18,000 had specific questions regarding landlord-tenant. The scheduling of landlord-tenant failure to pay rent actions did not resume until phase 4 of the judiciary's resumption of full operations, and that began on August 31st, 2020. As a result of the pandemic, in addition to other safety measures, the district court during phase 4 continued to limit the number of cases that could be heard in any courtroom to ensure that physical distancing was accomplished. The district court has worked to ensure plexiglass dividers are installed in courtrooms, sanitizing wipes are available, and non-contact temperature checks are done prior to entering the courthouse. Face coverings are mandatory in every courthouse. Staggered docket start times are also being employed to better limit how many individuals are seen at any one given time in a courtroom throughout the day. During the time that phase 4 and phase 5 lasted, fewer failure to pay rent cases were being heard in the district court across the state as prior to the pandemic as the result of these safety precautions. The district court also had worked hard to ensure the appropriate technology and hardware is installed in all courtrooms so that tenants or landlords can appear for their hearings remotely if they choose. Some jurisdictions are piloting majority remote dockets to help reduce physical contact. Many of the cases that have been heard since September have been cases that were pending prior to the pandemic, and there have been limited appearance rates of both landlords and tenants at these hearings. On November 16, 2020, the judiciary returned to phase 3 operations as a result of the rapid increase in COVID cases across the state. During phase 3, only rent escrow actions, tenant holding over actions, breach of lease actions, and wrongful detainer actions were heard by the court. The court continued to process warrants of restitution for failure to pay rent actions. And in phase 3, failure to pay rent filings were accepted by the district court, but were not set for a hearing. Any failure to pay rent hearing that had been set on or after November 16th was postponed, and those cases will be reset for a hearing when restrictions to court operations are lifted or modified. On November 24th, with an effective date of November 30th, the judiciary was forced to move back to phase 2 of operations due to that increase in COVID cases and the significant jump that occurred after the holidays or after the Thanksgiving holiday. This phase has been extended now to March 15th and will be reevaluated as circumstances warrant. During this phase, again, only rent escrow actions, and now the change between 3 and 2 was only emergency breach of lease, emergency wrongful detainer, and emergency tenant holding over actions will be heard. Any warrants of restitution that were pending will be reviewed on a case-by-case basis to ensure that if there are any defenses that they've been considered and or will be dealt with prior to the warrant being executed. As in phase 3, any failure to pay rent filing will still be accepted by the district court, but will be not set for a hearing at this time. Any failure to pay rent hearing that was set on or after November 16th, again, will still be postponed and will be reset for a hearing when restrictions to court operations are lifted or modified. In Baltimore City, an attorney of the day program has operated by the Pro Bono Resource Center since spring of 2017. In Prince George's County, the Attorney of the Day program is run by the Community Legal Services of Prince George's County and has operated since mid-year 2019. In Anne Arundel County, the county executive used CARES Act funding and partnered with Community Legal Services to fund a temporary dedicated landlord-tenant attorney and provide a small stipend to their network of pro bono attorneys willing to cover landlord-tenant dockets. The district court has been and remains willing and able to work collaboratively with any of these providers to facilitate the same or similar types of programs in other locations. Since the onset of the pandemic, the Alternative Dispute Resolution Office of the District Court has continued to handle mediation requests in collaboration with the Community Mediation of Maryland and local mediation organizations. The Self-Help Center that I mentioned previously, the District Court ADR Office, as well as the Maryland Judiciary's Mediation and Conflict Resolution Office, which we refer to as MACRO and deals more with the circuit court, as well as Community Mediation Maryland, have worked together to create a statewide call-in line to provide mediation services to the public. When the failure to pay rent cases were being heard by the court, the District Court ADR Office offered remote pretrial mediation services for both landlord and tenants. As a result of the governor's executive order and the CDC agency order, a judgment will not be entered against the tenant if the tenant successfully asserts the defenses provided in these orders until such time as the orders expire or otherwise amended. As I mentioned a moment ago, under the most recent stimulus funding bill from the federal government in December, the date for asserting defenses provided by the CDC agency order has been extended to January 31st, 2021. The district court will continue to work collaboratively with its justice partners and adapt its policies as the pandemic conditions warrant. And with that, Mr. Chair, and that is my testimony here today.
Thank you, Chief Judge. And I'm going to go ahead and break protocol. I know you might need to get back to some of your duties. So just to see if the members have questions for the Chief Judge, and if not, I know that we'll allow you to go about your day. So thank you very much for your presentation and your information.
Chair, I will stay as long as you need me to stay.
All right, that's even better there. Okay, great. Looking around the Zoom room, I don't see any hands up. I do see one. Senator West, given that the Chief Judge can hang loose for a little bit, let's go ahead and move along with our presentation, and then we'll ask questions at the end. Okay, thank you. All right, Mr. Hickey, you are up next.
Great. Can you hear me?
Yes, we're good to go.
Excellent. That's how we seem to start everything these days. Good afternoon, Chairman Smith, Work Group Chair Hedelman, members of the committee, members of the work group, other panelists. I'm honored to be here today to represent County Executive Olszewski and to have this opportunity to brief you on the county's efforts to address housing instability resulting from the COVID-19 pandemic. It's said often, but it's worth repeating, that the pandemic is an unprecedented event that's created a volatile environment where a lack of access to real-time data and sparse oversight and guidance from the federal government has created challenges for local jurisdictions in their efforts to lead efficient and strategic efforts to provide our most vulnerable individuals and families with assistance, particularly those that have found themselves unexpectedly in distress due to sudden job loss or other COVID-19 related factors. So I'm here representing Baltimore County. I know a number of the initiatives I'm going to talk about are going to represent what's going on in other jurisdictions as well. I'm going to try to represent the county's efforts to implement a phased housing stability initiative, and also to share challenges, lessons learned, and a few next steps. While much of this work falls on local jurisdictions, it's really only through collaboration and sharing of information that we're going to have a good chance of keeping up with this. Slide, please. Can actually skip to the next one. All right, so I wanted to start out. This is a snapshot, if you will, of Baltimore County's COVID-19 stability initiatives. You can see we chose a phased approach. I'm going to go through these quickly, but just here for summary. We started all the way back in June with what we're calling EPP Phase 1, Eviction Prevention Phase 1. For each of these, we've indicated, I think it's really interesting where funds come from for each of these programs. So you can see what we were able to allocate, the source of funds, and then a brief description of the program. We moved into EPP 2 in October of 2020 and are in fact still right in the middle of that phase. And parallel, we've started what I'll discuss in a minute called our Strategic Targeted Eviction Prevention Program, or STEP. And then, of course, I think something that is so important to discuss are the supportive services that go along with these different programs. Next slide, please. Okay, so here's a quick breakdown of EPP 1. Again, this launched back in June. This was our attempt to get funds out the door as quickly as possible with as few barriers as we could. At the time, I think we were all learning how to adapt to the challenges of COVID-19. We didn't have a lot of good data about what was out there. We knew that there were any number of existing eviction issues, and we were concerned, in fact, with some of the restrictions on CARES Act money and others that required COVID-related incidences and how to separate those from issues that people were already having. This was a program, we opened the portal on this for 5 days. So it was a fairly intense, short period of time. We used CARES Act funding that had been allocated directly to the county. We also utilized emergency aid for families with children. Our county DSS office was able to request a waiver early in the pandemic to use the money for this purpose. So we combined those together. We opened the portal in early June. We received 1,500 completed applications. We were able to fully fund 485. You can see that the average request was up around $2,700. We used a 200% federal poverty guideline eligibility standard. Of course, there had to be demonstrated COVID impact. You had to be a county resident. You can see over here, I'm not surprising anybody, but when you do a demographic breakdown, you can see that the large majority of applicants to this program were African-American households. I can break this down further to tell you the majority of those applicants were female heads of household. And you can see that the vast majority had children in the household as well, which unfortunately, but yet not surprising, we know that some of the greatest vulnerability to eviction lies in that population anyway. And this merely exacerbated an ongoing issue. Slide, please. I wanted to show you this. We've done quite a bit of work with our health department and BC Stat to try to track and analyze data as we get it. What this basically shows is the correlative relationship between socioeconomic variables, income, job loss, multi-generational housing, and then these outcomes related to risk of eviction and infection. So we overlaid housing density with tracked COVID cases, with our own eviction risk indicators. And again, I don't think it's much of a surprise, but it's worth reinforcing that these things are all indelibly tied together. We have to deal with the public health side of this emergency while we deal with the very real housing emergency that we have along with it. In fact, they're tied quite closely. Next slide. As additional funding sources came online, we started to open up new phases of eviction prevention programs. So what we called EPP2 launched in October. That portal remains open. We didn't do this for a limited amount of time. You can see we got quite a number of applications. We got at least 1,500 on the first day. At last look, 5,276, asking for a grand total of about 2.4 million in assistance. Why did we keep it open, folks might ask? First of all, one of the things Judge Morrissey referred to is the CDC directive, which allowed for an affirmative defense in court. One of those things you have to attest to is that you have made reasonable effort to apply for resources in your own jurisdiction. As we moved people onto a wait list and tried to find more funds to keep this program going, we wanted people who applied to have the opportunity to go into court and say, I applied to Baltimore County, I have confirmation, I'm on a wait list. And so we continue to do that. However, with the new funding coming online, particularly state CDBG funds and also this new CARES Act funding, all of it has a substantial number of restrictions built into it, particular to those individual funding sources. So like many jurisdictions, we're looking at our existing eviction prevention programs and trying to decide whether we need to open up new phases or continue to layer the money into this existing work. The interesting thing about our phase 2 is that this is being rolled out almost predominantly through nonprofit partners. We did a competitive RFP. We selected 6 nonprofit entities and 1 government agency. We are referring the cases out to those organizations. This is a fully case managed model. And the good thing about that is we notice that the denial rates are lower because there's an opportunity to really dig into the issues with each family that applied. The challenge is that can take time. It takes time to reach people. It takes time to get them to collect the documents. And so this one has been more of a crawl than a sprint. But we are going to continue this particular phase as long as we can continue to add funding. And you can see from the bottom that the demographic breakdown is very similar to EPP1. Next slide, please. Quickly, this is a geographic comparator of phase 1 and phase 2 that shows that there's a tremendous amount of overlay. There's not much difference between the phases. The density or intensity of the cases are much larger in phase 2, of course. Next slide. And this is the same analysis from a zip code. And you can see again that the intensity of these cases have remained pretty similar from phase 1 to phase 2. Next slide. Okay, I want to take a second on this. While phase 2 was going on and we realized we needed to do more to try to reach a larger number of tenants in a much quicker period of time, both because of the ongoing trauma that tenants were facing, but also because, if you remember at the time, there was concern as to how long we'd be able to spend CARES Act money. So what the county did was it bundled together the CARES funding that it had available. And we engaged in this collaborative venture with the United Way of Central Maryland that we're calling the Strategic Targeted Eviction Prevention Program, or STEP. Unlike EPP2 and earlier phases, which required individual tenants to apply one case at a time and could often take a while to process their applications, STEP was designed to move financial support quickly and efficiently to hundreds of tenants in a matter of weeks. Essentially, the United Way works as a partner with the county, the Maryland Multifamily Housing Association, and individual property management companies to bundle applications from large properties. It's incredibly data-driven. The county mapped out the zip codes that had the highest growing number of COVID cases and also the greatest risk of eviction. We went in order of zip code. We identified the large properties within those zip codes, and the United Way approached them for participation in this pilot. We had approximately 23 management companies sign up, 99 total properties. As part of participating in this program, the landlords agreed to off the top forgive 20% of past due rent, waive all fees and costs. And Judge Morrissey, you'll see clearly they were also asked to dismiss any cases that they currently had on the docket. We worked pretty intensely with Judge Wilson and our local district court in the planning of this pilot. We focused on Class C and D apartments. We also dug in a little deeper and wanted to focus on vulnerable households with at least one senior or one minor child living in the unit, owing 3 to 9 months of rent and some loss of income due to COVID-19. As I think will be very important as lessons learned, we developed an affidavit that tenants could fill out where they could self-certify the impact of COVID if they felt they would have difficulty in providing all the different documentation that was due. And this particular phase of this was all funded by the county's allocation of federal CARES Act dollars. And then later, through an added allocation of state CARES Act dollars as well. Slide. This kind of shows you where we are on STEP. These are the priority zip codes. We've now opened up 3 total phases of the program. It shows you the number of households and the projected rental assistance. I did get an update this morning, and I can tell you that at the bottom, this is increased to 963 households, just over $4.1 million committed for an average award of about 4,200. And the first check started going out to management companies this morning. So we'll be monitoring this closely and continuing to tweak the model, but we're hopeful. Again, I just want to emphasize over about a 6 to 8 week period, this will allow us to cure the rental arrearages of almost 1,000 households in the county. Slide. I want to put this up here for a second. I think it's important, I can throw numbers at you, but we've learned a tremendous amount. And I also want to emphasize the counties were forced to launch their own programs early on in this pandemic. And while we've taken different approaches, there's a number of similarities. We meet regularly to share lessons learned. We realize the situation continues to be volatile, and it may and probably will only get worse. Collectively accessing data, court data, eviction data, sharing what we know with other counties, getting assistance in this with the state is critical. We've also realized in many different ways, we have to continue to limit the conditions to receiving the awards of this money. We need to really be critical in scrutinizing any restrictions that are required of tenants and in some cases landlords. These applications have to be user-friendly. We need to make it easier to submit supporting documentation. We really need to think about the balance between efficiency and equity. The more restrictions we place on this money, the less chance landlords and tenants will participate or will be able to participate. We've learned a great deal from surrounding states in the challenges they've had, and we've had some of our own challenges that we've had to overcome. Next slide. Just a quick reference to supportive services. I've seen in previous hearings where it's been talked about that we can't simply rely on financial assistance. Baltimore County and I know other surrounding jurisdictions have entered into contracts. We're working closely with Maryland Legal Aid, the Fair Housing Action Center of Maryland, CASH, and our own Baltimore County Department of Economic and Workforce Development, using initially CARES funding and then local and federal funding to maintain these into the foreseeable future. Next slide. Some other things that we're particularly proud of, in particular food distribution, having reached a pinnacle of 10 million meals throughout this. Next slide. And then finally, I'll leave this up for a second, but I want to summarize by saying collaboration in this work has been key. The conversations with the county internally, learning how to work together between different departments and agencies, learning how to share information in real time with the state and with other counties, with philanthropic entities, regular meetings with nonprofit providers. It's easy to feel separated from this work. We need to stay on top of trends, continuing to track data are all important. So I will leave it at that. I will be here this whole time, available for questions at the end. And Mr. Chair, if there's anything that I and the county can do to help as the work group's efforts move forward, we're here to assist. Thanks again for having us.
Well, thank you very much. And thank you, Mr. Hickey. You should be commended for your work and the county, what you're doing. And you prompted me to inquire as what Montgomery County is doing and maybe enlist some of those best practices. So thank you for this presentation and information, and thank you for the work you're doing. I'm sure we'll have some questions forthcoming from the members.
Thank you.
So thank you very much. So Ms. Hatfield, you are up next. Are you ready to go? I see you there.
Yes, I'm ready to go. Mr. Shaw and I will be presenting together this afternoon.
Great, fantastic. How are you, Mr. Shaw?
Good, thank you, Mr. Chair.
Good, good.
Can you hear me okay?
Yes, you're good to go.
Okay. Well, I'll get us started. So I'm Zafar Shah, attorney in the Human Right to Housing program at the Public Justice Center. I'm joined with Carissa Hatfield, also an attorney at the Homeless Persons Representation Project. We both practice in the district court defending against eviction. And we're here today to talk about some further context. And there's some overlap. I'll apologize ahead of time, overlap with Judge Morrissey's testimony and Mr. Hickey's. But we'll provide more of a ground up view, I think, in terms of what's happening in the district courts. Next slide. And next one. Thank you. So since our organizations were last before Judicial Proceedings Committee in May, we've heard from countless renters across the state who are dealing with two crises. One is the public health crisis of COVID-19, and the other is the financial struggle to overcome what has basically been a collapse, particularly among working families and households of color. Just to put some numbers to that, we know that from the Census Household Pulse Survey data, the most recent data for the first week of December, 30% of households in Maryland earning less than $50,000 could not pay the last month's rent. That's compared to 10% of those earning more than $75,000. And there's a disparate impact, if you will, on households of color, which I think this goes to what Mr. Hickey was testifying to very well. 36% of Black households at the beginning of December couldn't pay their rent, compared to 14% of white households. Now, 14% is still higher than what you might contend is a normal amount of delinquency in the state of Maryland. Next slide. Overall, our total projected rent shortfall based on the Household Pulse Survey in January 2021, it far exceeds $206 million. That, is overwhelming compared to the 49 million that we estimate that has been granted from the Hogan administration to the different counties and from the federal government to directly to local jurisdictions. The anticipated $402 million allocated from the Appropriations Act recently signed, that will go a long way to helping families with not only rent, but also with utilities, case management services, and legal services. But if there's anything that I'd like the committee to take away from what's happening with rental assistance is that it takes a long time for that money to devolve down to in a meaningful way to helping renters and their landlords. As Mr. Hickey was alluding to, it could take weeks to assist just 1,000 households in a particular jurisdiction. And next slide. And what the figures that we can, that Judge Morrissey explained, that we can look at online here, what these really show is that there are over 2,000 500 households that have been evicted during the pandemic. Let that sink in. Those are all, I would contend those are families or individuals that were in the process of trying to get rental assistance, trying to get any type of assistance to avoid losing their home during a pandemic. And the greatest factor in whether someone has time to get that assistance is whether the court is open or not, whether the process is moving along like normal or with the precautions that Judge Morrissey described. What hasn't been effective, we'd contend, or as much as everyone had hoped, were Governor Hogan's executive order on evictions and the CDC order halting evictions. And Carissa's going to explain that a little bit more in detail.
Thank you. Next slide, please. So as some on the committee may be aware, Governor Hogan first issued an executive order on March 16th and has most recently extended it to December 27th of 2020. Courts at this point are restricted from ordering the eviction of any tenant who can show that their failure to pay rent or breach of lease was a result of COVID-19 because of lost or reduced employment due to the emergency. And these prohibitions are in effect until the state of emergency is lifted. As Judge Morrissey alluded to, and I believe Mr. Hickey did as well, the governor's order is not a moratorium. It does not stop evictions. As Zephyr just stated, there have been evictions that have occurred since the state of emergency began. It acts as an affirmative defense in an eviction proceeding. And while this defense does exist and it can be helpful for a tenant who understands how to use it, what we were finding when the courts were back in session and tenants were appearing before judges in failure to pay rent cases is that they often didn't know how to raise this defense. They didn't understand what they needed to say in order to make that work for them. And the levels of proof that were required by judges varied greatly from judge to judge, from tenant to tenant, to demonstrate that there had been a substantial loss of income due to COVID-19. This obviously presented challenges for tenants who were unrepresented or unfamiliar with the executive order, who may have been rightly entitled to use this defense and stop their eviction. Next slide, please. Could you go back one? I apologize. Thank you. The CDC also issued an order which was effective September 4th of this year, which demonstrated that tenants could provide a declaration to their landlord stating that they were eligible to have their eviction postponed due to the emergency based on a number of qualifying factors, including, as Mr. Hickey cited, their ability to have sought financial assistance, or the fact that they may have been unable to substantiate or maintain other housing in the event of their eviction. Again, despite the fact that this did help some tenants, it was not a total eviction moratorium. This meant that tenants, again, had to understand what the CDC order was, know it existed, and know how to bring it up properly in order to use it as an affirmative defense in court. It was also challenging for tenants for a number of factors. One of those factors being that some tenants are simply not currently qualified to apply for financial assistance programs. And that is a requirement of the CDC order, is that a tenant apply for these programs. Tenants in, for example, subsidized housing were not eligible for the first wave of financial assistance, and were not eligible to apply for the first wave of assistance, which meant they could not use the CDC order in order to assist them in avoiding eviction. At this point, the other challenge that exists with it is that the order only temporarily in Maryland stops an eviction. A judge can enter a reserved order when the failure to pay rent court was operating. They could issue a reserved order, in other words, an order that was not being a judgment at that time, but would be entered as a judgment after the time that the CDC order ended, which initially was December 31st and is now January 31st. So this timeline is temporary, and there's no expectation at this point, I think, that it will extend beyond the 31st of January. this eviction order from the CDC. Next slide, please. And Chief Judge Morrissey went over some of this already, so I apologize for duplication, but just briefly, the courts, of course, are in phase 2 until March 14th, which is rent escrow, emergency breach of lease, emergency wrongful detainer, and emergency tenant holding over. I do want to emphasize that even though the court is not hearing failure to pay rent matters right now, any judgments that were entered before November 23rd can still be executed. Next slide, please. Evictions resumed in Maryland on July 25th after a stay by the court due to the Federal CARES Act and restrictions from the Court of Appeals, Chief Judge Rivera's order from April of 2020. Nearly 117,000 failure to pay rent cases, tenant holding over and breach of lease were filed in July through November. And as I was saying, warrants of restitution that were for matters decided before November 23rd can still be issued. So in other words, tenants are still being evicted right now, even though the courts are not currently hearing failure to pay rent matters. And as Zephyr mentioned earlier, 2,547 evictions have been executed between July 1st and November 30th of 2020. So we do want to demonstrate and emphasize at this point that even though the courts have restricted their operations, and that is a good step in the right direction, tenants are still being evicted right now, and those tenants are being placed at risk of exposure and harm during this public health crisis. And I would like to briefly turn it over to Zephyr to go over some of the numbers that we're seeing and talk about some of the public health concerns.
We'll skip to slide 12. Thank you. Next and next. So this was briefly mentioned by Mr. Hickey about Baltimore County, that they were able to identify a correlation between eviction or risk of eviction and COVID-19 case counts. And this is not Baltimore County alone, of course. This is happening across the country. And emerging research has shown that, for instance, the lifting of eviction moratoria was associated with increased COVID-19 incidence and mortality. You can see that these researchers, including Kate Leafheit, who was formerly of Johns Hopkins Bloomberg School of Public Health, they found that when Maryland resumed evictions as of July 25th, they projected 2,310 excess COVID-19 cases as a result of the reopening of evictions, including 37 excess deaths. Next slide. And of course, additional research has shown that the excess morbidity, the incidence, this is all impacting communities of color greatly. There's a racial health inequity that has to be addressed, and we contend one of the ways to address that is through eviction reform. Next slide. So Chris is going to tell us about Holly.
Thanks, Zephyr. So Holly is a client of mine currently, and she is a human trafficking survivor living on limited income from her employment here in Baltimore City. Holly was living in an apartment that she was paying for. It was a struggle, but she was paying for in Baltimore when she was evicted in August of this year. And this was a month after the moratoriums were were lifted. So she was able to be evicted at that time pursuant to the court orders and state guidelines. Holly has been moving from place to place prior to this housing. She was, for the first time in a long time, stably housed as a result of her trafficking and other issues. And she was extremely traumatized by her eviction. It was the first opportunity for stable housing that she had had, and she had lost it. And she had nowhere else to go. She had friends that she was living in, that were her neighbors, a couple of other friends that were currently working, but she did not want to risk either getting COVID from them or her giving COVID to them. So she decided that she could not stay with them. As a result, Holly was forced to enter non-congregate emergency shelter in September of this year. She's been in and out of the shelter since that time, and has been unable to return to living in stable housing during this pandemic. And if Holly had been able to stay in her home, she wouldn't be facing housing instability currently, and increased exposure to COVID-19. And those are the things I think that we're all searching for in this pandemic, is to ensure that as many people as possible limit their exposure to this public health crisis and to maintain stable housing. And because of people like Holly, we continue to do this work. So now I'd like to talk about some of the things that we could try to do to help prevent cases like this from happening. Next slide, please. So I'm going to talk first about some of the emergency renter protections. The eviction moratorium that Senator Smith is working on. The CDC cites eviction moratoria as an effective public health measure to prevent the spread of diseases like COVID-19. And we know this to be true based on working with our clients and seeing how this public health crisis has affected those who are unstably housed. A legislated eviction moratorium, it should close a lease termination loophole, which I'll talk a little bit more about in a second. And it should prioritize creating clarity for tenants and for landlords on what a prohibited eviction is versus what a permitted eviction is at this point in time because of the public health emergency. And it should last long enough that Marylanders can maintain housing stability throughout the public health crisis and through the economic recovery that we know is going to take some time. Next slide, please. So talking a little bit more about the loophole in lease terminations, neither the governor's order or the CDC order protect against non-renewal of leases due to non-payment or rent or other no-fault violations. So in other words, a landlord who cannot currently go through and finish or execute a case through the failure to pay rent docket can still file a tenant holding over case stating that they're terminating the lease, and that reason can be because of non-payment of rent. So this is a loophole that's been created, and landlords are taking advantage of it. We have seen an increase, as you noted from the numbers that Chief Judge Morrissey presented, as well as Mr. Shaw presented today, that there has been a dramatic increase in tenant holding over filings since the courts have restarted their processes. And according to an article that was recently published in the Baltimore Sun, landlords have been using this as a means to evict tenants who have fallen behind on their rent due to the pandemic. Creating a prohibition on non-renewals without cause would increase utilization of rent relief, decrease housing instability and homelessness during a public health crisis, all things that I think are our goals here. Next slide, please. Prohibition on late fees and rent increases. So Baltimore City and Montgomery County have prohibited the charging of late fees and some rent increases. Baltimore City has put a total prohibition on rent increases at this time. Montgomery County has put a cap, I believe that is between 2.5% and 3% on rent increases during the state of emergency. And some other jurisdictions have instituted similar policies. However, this isn't true in all jurisdictions. So there are tenants in other jurisdictions that don't have these policies who can be subjected to late fees based on failure to pay rent due to falling behind in the pandemic and state of emergency, losing their employment, and may also face rent increases during this time as well, that they will cause them to fall further behind on the rent. A statewide prohibition on late fees and rent increases would create consistent public policy and allow households that are financially struggling to not fall further behind. And I believe, next slide, please. I am going to turn it over to Zephyr here to talk about the rest of these reforms that we're looking at.
Thank you. So there are very few good things that have come out of the COVID-19 crisis, but I think one thing we can look at as a positive has been the real paradigm shift in how eviction prevention is occurring in Maryland. We've had a system for decades that prioritized imminent eviction through court order as a predicate for a renter to receive any type of rent relief. And that has been flipped to prioritize early intervention even before the court process. But what we've seen with public justice center clients and HPRP clients is that landlords continue to resort early to the different legal processes, not just failure to pay rent, which has been delayed comparatively to a normal year, but also tenant holding over, as Carissa was just talking about, as well as breach of lease. One of, I think, the projects for JPR to undertake with all legislators is to really think structurally and reform the eviction process, not just with an eye towards COVID-19, but with an eye towards understanding what in the eviction process has been preventing landlords and tenants from getting their dispute resolved without quick resort to litigation and potential housing displacement. So we've got to change the eviction process, particularly in the failure to pay rent process, from rapid adjudication to one that prioritizes eviction diversion. And we really we want to see policies, and Senator Sidnor and Delegate Melissa Wells will have a bill that really does put a onus on the landlord to resort to rental assistance and mediation in concert with the tenant before an eviction can be filed. So that systematizes first resort to other types of dispute resolution rather than early use of litigation and judgments. We propose that the district court, along the same lines, not just be a court of collections, but really a hub for holistic problem solving, facilitating service triage of litigants at the district court. And really that occurs when the first time litigants are interacting with the district court is with a status hearing rather than a quick trial. And so bifurcating the process of summary judgment into a status conference styled proceeding where judges can direct litigants to undertake negotiation or to be triaged by legal services or financial services or even social services. That is a best practice that we've seen in New York City's housing court, Boston's housing court, and other places throughout the country, which have seen that eviction diversion holds much more promise for creating housing stability as well as remuneration to landlords. Next slide. So if litigants must go to trial, in this proposal, courts would follow a set structure of providing a later trial date, allowing tenants to seek legal counsel, formally raise a defense, and even seek limited discovery as directed by a judge. This is systematizing and institutionalizing what I think advocates would like to see at any time, regardless of whether there's a crisis. But all these things, even if you're looking at how the CDC order, the Governor Hogan's order has played out, all these things would be helpful in the near term. We also want to see judges have greater power, which they don't have today, to stay proceedings because of a defendant's critical medical need, or to enable charitable or governmental programs to assist with seamless transition from the threat of eviction to rehousing without any gap in having housing. Next slide. Part of the, I think, sort of cocktail of reforms here for the eviction process has to include right to counsel, which has been demonstrated to be effective in preventing housing displacement. I don't need to go into this in detail because I believe almost half the committee has sponsored SB 154, which will be in hearing later this month. Next slide. And finally, putting on a different hat, which is a co-chair of the Housing Security Committee for the Attorney General's COVID-19 Access to Justice Task Force. I do want to just preview that the Office of the Attorney General will also be forwarding an important reform, which is to really reduce the crush of eviction case filings. As Judge Morrissey was saying, about 55,000 eviction case filings is the average just in a typical year in Maryland. Part of reducing litigation and prioritizing other types of dispute resolution is to increase the barrier to entry. And right now, Maryland has a bottom in the nation court fee for filing an eviction, which is between $15 and $30 around the state, and increasing that to just the national average of $120 per filing would, we project, greatly lower the amount of litigation and increase the judiciary's, the court's resources to handle other types of dispute resolution, including the Office of ADR, and providing more services just to have fair trials. So those are our sort of suite of renter protections. Chris is going to also talk very quickly about what's needed to prevent a foreclosure crisis in the coming year. And we'll wrap up. Thank you.
Thank you, Zephyr. Next slide, please. Next slide, please. So briefly talking about homeowners, Governor Hogan's executive order, which we've discussed so far in the context of renters, also had provisions related to homeowners, which has most recently been updated in December. It provides that homeowners may have up to 12 months of forbearance for a non-federally backed loan, and establishes a foreclosure moratorium through the end of this month. After January 31st, the order requires loan services to notify their borrowers of forbearance rights and grant request forbearances before proceeding with foreclosure. Next slide, please. So under the CARES Act, which was signed into law on March 27th of last year, the following protections were provided to homeowners. Borrowers who had government-backed mortgages, so things like Freddie Mac, Fannie Mae, VA loans, were permitted to postpone or reduce their payments for up to 12 months. So the initial period of forbearance for those individuals with a federally backed mortgage was 180 days. And then if there was continued crisis, the borrower could extend by an additional 180 days. These protections are available if the borrower states to their servicer that they've suffered COVID-related financial hardship. There's no other evidence that needs to be provided other than the borrower's statement. Next slide. FHA mortgages have issued the following guidance related to foreclosure. For federally backed loans, lenders and loan services cannot foreclose on any mortgagees of a federally backed loan until after February 28th of this year. And for loans backed by Fannie Mae or Freddie Mac, that is a little bit different. It's currently set at January 31st of this year. Mortgage holders with a federally backed loan may request and obtain forbearance for up to 180 days with COVID-related financial hardship. Next slide, please. Thank you. So just briefly talking about some ideas or thoughts that we have come to the table with as far as reforms for homeowners to prevent foreclosure and a foreclosure crisis. We would suggest a codification and extension of the foreclosure moratorium through the state of emergency. So not ending anytime soon, but when the state of emergency is actually ended. And this is both beneficial to small homeowners and landlords who are currently having difficulties with possibly paying their mortgage if they're unable to maintain rent payments from their tenants who have also suffered from COVID-19 hardships. So this is a protection not just for individuals who own their homes, but also small landlords who are continuing to try to operate their business. It would require mortgage servicers to grant forbearance relief through the state of emergency. So for mortgagees who are continuing to have financial struggles due to the COVID emergency, it would grant them forbearance relief. And then finally, for both homeowners and small landlords who have exhausted forbearance options, it can establish, we would suggest establishing that their default repayment option be not owing that amount after any forbearance or state of emergency is up, but rather deferring missed mortgage payments to the end of their loan to not create any additional financial hardships once the state of emergency is over or forbearance options are exhausted. That is the conclusion of our presentation. I do want to thank the chair and the vice chair and the committee for the opportunity to be heard today on these critical issues. Thank you very much.
Hey, thank you both for the outstanding presentation and for your work. I know that the members of the committee have a copy of this that will be forwarded to them if they already have it in their inbox. So thank you very much for your time, and we look forward to working with you in a few weeks. Next, we have Mr. Greenfield, Mr. Skolnick from AOBA. Are you all ready to go?
Yes, Mr. Chairman, we are. I think you.
Hey, Aaron, I think it trailed off at the very end there.
I'm sorry. Instead of Mr. Skolnick, I think you mean perhaps Mr. Chairman Aaron Bradley.
So it is so, yes. Hey, Aaron, how are you, Miss Bradley?
Doing well, Mr. Chairman.
All right. Well, yes, we're ready to go. Take it away.
Slide 2. You can go to slide 2.
Yeah, thank you. So briefly, who we are, AOBA and MMHA members, as you can see, own or manage over 339,000 rental housing units across Maryland, and they house almost 885 Marylanders. So AOBA members own or manage 133,000 apartment rentals in Montgomery County and Prince George's County, which comprise nearly 17% of all Montgomery County's housing and nearly 20% of all of Prince George's County's housing. MMHA membership consists of over 200,000 units across Maryland, of which comprises 42% of all rental housing in Maryland, excluding, of course, Montgomery and Prince George's County. And it's about 89% of all units of housing greater than 5 units. So these two organizations represent a good amount of the rental housing in the state of Maryland. Next slide. As you can see here, people often, there's a misconception rather that, and people often assume that there are huge margins in rental housing. And you'll see from this, this graphic that only 9 cents of every $1 are returned to the owners, the apartment owners and community owners. Of that money, 39%, so the bulk goes to the mortgage of the property, 27% goes to operating and upkeeping the property via payroll expenses, 10 cents of every dollar go to reinvestment in the community and property and upkeep, and the remaining 14 cents of every dollar taken in rent goes back to the community in the form of property taxes. So that's just an important thing to think about, the ways that the rent money gets broken down. Next slide, please. Just a little overview of Maryland's rental housing industry. Maryland's rental housing industry is made up of Class A, B, and C properties. So Class A are the new and high level, the newer buildings with high level or luxury amenities. Class B properties are usually renovated properties with fewer amenities. And then Class C properties are usually 20 years or older. They have fewer amenities and often require renovation. Class C certainly is what we think of when we think of our market rate affordable, and Class B properties occasionally fit into that as well. That'll be important to know later when we talk a little bit about rent collection. Really, those Class C properties are the ones that are unassisted or affordable without assistance. So we also in Maryland have a mix of professional housing providers, which AOBA and MMHA often represent, but there's a large number of smaller housing providers, the individual or accidental landlords who are renting out a unit or two. and people who just own small buildings, one building perhaps. And pre-COVID, there was a really strong rental market, low vacancy rates. So we were enjoying a pretty strong market prior to COVID, which changed so much. Next slide, please.
So, Mr. Chairman and members of the committee, Aaron Greenfield again on behalf of the Maryland Multi-Housing Association. I think we'll press with AOBA two key points in this presentation. One is, we really avoided the eviction process by ensuring there's rental assistance and making sure that there's rental assistance in a fast and efficient way. And secondly, that this industry, as you'll see in the data, it has not been in any way immune from the pandemic. We're also facing the very same challenges as every other industry, and we're no different. Here's some key data points. The percentage of residents who did not pay rent has increased slowly over the past several months, about 7% higher than the pre-pandemic average delinquency of around 10%. As Ms. Bradley mentioned, Class C properties, also known as naturally occurring affordable housing, have been hit the hardest, with delinquency rates averaging 33% each month. I'll repeat that, that's 33% each month for Class C properties. As the Chief Judge has mentioned and others, the courts are currently in phase 2 until March 14th, and failure to pay rent cases are not being heard at this time. The governor's executive order and the CDC eviction moratorium are still in effect. Both our organizations, AOBA and MMHA, I should also mention, have worked alongside a number of the jurisdictions in the rental assistance program as a way to kind of stem this and really direct mostly the Class C properties into rental assistance program. And I know we applaud Mr. Hickey in Baltimore County and United Way for their STEP program, which we've taken an active part in, and would agree with Mr. Shaw that really it's so important that these funds are released and get out into the street as quickly as possible. Next slide, please. So MMHA does a survey a couple times a month. This may be hard to see, and we're happy to, obviously, the committee or we can share, but we survey our members and usually get about 100,000 units surveyed. And what this shows in this chart is for 2020 delinquency rates mid-month to month's end. And the bad news, of course, is, as you'll see, is delinquency is up. Again, the point being, this industry isn't immune in any way from what, just because we may represent larger property owners, we still have tenants that are struggling, which means we too are struggling. And I think that's what this and the next slide represents. But interestingly enough, in this slide, which we've presented previously to the committee, is you see in the blue bar, you see that that tenants are paying through the course of the month, which I think is an interesting note and suggests that some of the points that we've been consistently raising is the importance between communications between the landlords and the tenants. And that, I think, has fostered that open line of communication. Next slide. The next slide details the delinquency rates, 2019 versus 2020. And you'll see it's fairly significant. As I mentioned before, you're looking at about, average of 5 to 7% year over year, if not a little bit more in some cases. We have, our data has suggested again that the Class C properties are, reaching, levels of 32 to 33% a month, which is largely what attributes to the increases you see in the blue. So I would, sort of leave you with the fact that, again, our industry is not immune at all from the impact here, particularly those property owners that have Class C properties in their portfolio. Next slide.
So one thing we'll note is that housing providers have really innovated the way they're doing business to support residents during COVID. Outside of just the tangible investments rather they've made in their properties to ensure social distancing could be maintained, and hand sanitizer, touchless entryways, and those things. They've also really innovated the way they communicate with residents, and the way that they're looking at creating payment plans and other new creative solutions to address families' individual needs where that was possible. Housing providers have also taken a pretty significant role in sharing government and nonprofit resources with residents. For instance, in Prince George's County, not only did they share the information about rental assistance, but they also worked hand in hand with residents to apply for the rental assistance on the residents' behalf to make sure that applications were in and well received, and that residents understood what was being asked of them. And finally, housing providers have begun initiating resident check-ins, expanding virtual social services, as well as other virtual services and service provision. So just a lot of innovation to make sure that residents were supported and assisted in as many ways possible during this pandemic. Next slide. Sorry.
So much of this has already been covered, Mr. Chairman, so I'm not going to waste too much time on this slide, except to point out that as part of this Consolidated Appropriations Act, we know that there'll be about $25 billion through September 30th, 2022 for rental assistance. Based on state population, we also know that no state will receive less than $200 million. So I think it's sort of important to make the note that as the General Assembly contemplates what it intends to do in terms of raising fees and those kinds of things for perhaps rental assistance, which our organizations support rental assistance. But when you go to look at those fees, I think it's important to keep in mind that a significant amount of money will be fortunately coming to Maryland through this Appropriations Act. Next slide.
And so both Aaron and myself will be here to answer any questions, but we want to leave you with this. It would encourage constituents to communicate with their housing provider. We recommend that residents come to property management staff as soon as possible to discuss payment options, the issues they're facing, and what options are available to them if they open the dialogue early. And we've been encouraging this since the very beginning of this pandemic. Opening the dialogue early and engaging often can really help us not have to fall on, or help the industry rather fall on some cases of last resort efforts of eviction and other things. We want to work early with residents. Next slide. Thank you.
All right, great. Well, Aaron and Aaron, thank you for that. Sorry, my apologies for the Adam mix-up, but thank you both for the presentation. I know we have the materials available to us, so we will probably have some questions at the end, but we will move on now to Mr. Enton, Ms. Lehman, and Mr. Luby. So Bob, you're up.
Well, thank you very much, Chair. And I think I'll go ahead and lead off.
Okay,
I'm Mindy Lehman with the Maryland Bankers Association. And as you just said, with me here today are Mr. Bob Enton, who is our General Counsel. And I'm very pleased to introduce our incoming President and CEO, who is Mr. Ramon Luby. So Ramon's first day is actually January the 11th, but I'm thrilled he was able to be here with us today. And of course, he replaces an individual many of you know very well, Kathleen Murphy, who served as the president of the Maryland Bankers Association for 20 years. And Kathleen is now heading up the Massachusetts Bankers Association. So she's the MBA, the head of the MBA to the north. So Bob and I will cover the substance of our presentation today, but we did want to take this opportunity to introduce Ramon to you, Mr. Chair, and to the committee. And Ramon is a Maryland resident. He lives in Howard County, and he has represented Bank of America in Maryland for the last 4 years. He's been incredibly involved in the Maryland Bankers Association through a number of activities, including serving as an MBA board member. And I think you'll enjoy getting to know him, and he's a subject matter expert and certainly brings a wealth of talent and expertise to the association. And Ramon, would you like to say a few words before we move on to our presentation?
Absolutely. And Mindy, thank you so much. And I want to say just thank you to the chair and the vice chair and members of the committee for providing this platform. There are a number of important topics of discussion, and Bob and Mindy will cover a number of data points and updates from MBA's members. But I look forward to working with and meeting the members of this committee in the future. And, I'll leave you with this. MBA's members, since the beginning of this pandemic, have been hard at work to support the customers, clients, and communities they serve. And so Mindy and Bob will talk to you a little bit about that. But thank you so much for the opportunity to be here with you today.
Thank you, Ramon. And Bob, can I turn it over to you for some opening comments before I step the committee through our PowerPoint presentation? You're probably muted, Bob.
Good afternoon. I'm Bob Enton. I've been General Counsel to the Maryland Bankers Association, I guess, for at least the last 30 years, and appear in front of your committee regularly and have for decades on banking issues. We had a briefing, I guess, Mr. Chairman and members of the committee, back in June or July, I think. And now we're back here in January, 6-7 months later. I guess one of the things I feel good about is that I think it's very clear, particularly when you listen to the presentation of the housing advocates, that Maryland and the federal government have done an excellent job of addressing the forbearance issue. Even the recommendations from public justice are basically to, in some way, codify what the feds have done and what the governor has done. I think regardless of your political affiliation, no one can look at what Governor Hogan has done as far as issuing orders and say that Maryland's not been addressing the foreclosure issue. Under the federal orders that are in effect and will probably stay in effect, if your loan is in any way connected with the secondary market, you must offer periods of forbearance to the borrower. And the borrower doesn't have to furnish any proof whatsoever that they can't pay because of COVID. All they have to just do is put that in a statement, and then they're entitled to forbearance of up to, under the current program, 360 days. That's 1 year. And then what the governor did in his order that he issued back in December was to basically say, we're going to require everything that's required at the federal level for these secondary market-backed mortgage loans for them and for the non-secondary mortgage-backed loans. So what the governor's order does is it applies to every single mortgage loan in the state of Maryland. And what it does is it says, as do the feds, that if all you've got to do is say, I can't pay because of COVID, and guess what? You don't have to pay. It doesn't matter if it's Bob Enton or Ramon Luby or Chairman Smith. It makes no difference. All you got to do is say, I can't pay because of COVID and I don't have to pay. Now, that's the reality of it. Is that what we would rather obviously have had at least some kind of affidavit, but that's not what's in place. Secondly, what Maryland does, which no one else to my knowledge has done, and which the feds don't do, like what the governor's order says, is that effective February the 1st, and we've had a total stay in effect in Maryland since April the 3rd. And effective when the mortgage, when that order expires and this new order basically goes into effect, what it says is that the holder of the mortgage will have to send a notice out to the borrower, and this is on all mortgages, if they want to foreclose, advising them in writing that they have the right to forbearance. Now, no one, this is not required at the federal level. So really but at the state level, every single borrower will be put on notice has to be put on notice 30 days before the notice of intent to foreclose is filed. Will have to be put on notice that they can get up to a year's forbearance. And all they have to do is ask for it. So that's really dramatic. And I guess one of the things that concerns me a little bit is that this is as we all know, is such a moving environment and such a moving picture, whether you're talking landlord, tenant, or foreclosure, whatever it is, health, you name it, is, we're going to meet. Hopefully we'll get through a full session, but we're going to meet and then we're going to adjourn. Whether we adjourn like we did last year in March or we adjourn in April, we're going to adjourn. And I'm very nervous about the fact that as the dynamic changes, and maybe it'll change one way or change the other, that whatever you pass is not going to be able to remain is going to be a done deal until we go back into session again. And I think, that I don't think anyone can make the case at all. And certainly the previous witnesses didn't make the case that the federal government and the state of Maryland, and the state of Maryland way beyond what the federal government has done, has addressed the foreclosure issue in a very dramatic and meaningful way. And sometimes, the proof is in the pudding. And it's interesting. I think when we testified before the committee back in the early summer, I think we made the statement that, notwithstanding the fact that COVID kind of really hit home in March, and back in June or July, I think Ms. Murphy or I said that we haven't had a single complaint, or even not even a complaint, just a reach out, an outreach from a legislator about a constituent that's had a problem dealing with their mortgage lender. And so when Mr. Luby and Ms. Lehman and I had a call this morning to prepare last minute kind of preparation for today's presentation, I asked Ms. Lehman, I said, have we, I'd like to know whether or not that is still the case. And she checked, and it is still the case. So, and I would encourage you that if you do have problems, or you hear from constituents have problems, and you don't feel like they feel like they're not getting through to their lender, to let us know, and we'll get through to the lender. But I think it's reflective of the fact that the Maryland Bankers Association, Maryland Banks, and Ms. Lehman will go through the slides on this, and the bank commissioner, Commissioner of Financial Regulation, and the governor have all taken tremendous steps and really worked hard to make sure that borrowers are being protected. And I would just close my comments by saying the very, very last thing in the world that any lender wants to do is foreclose. The last thing they want to do. Right now, the average length of time to go from default until sale in the state of Maryland is 545 days. It's almost a year and a half. It's almost exactly a year and a half, I guess, to go through the foreclosure. A year and a half. And we have, for the JPR committee, we've got pre-file mediation. We have post-file mediation. We have requirements for notices and for the information that lenders have to furnish. And that's why our foreclosure rate has remained very, very low. All you got to do is pick up the phone and call the toll-free number for your lender. And the first words you're going to hear in the recording are, if you're having a problem paying your loan because of COVID or for any other reason, please press 2 or 1, or please call this number. We don't want to foreclose. There hasn't been a surplus in a foreclosure case that I'm aware of since 2007. So what benefit is there to us foreclosing instead of working with the borrower? So I'll stop and ask Ms. Lehman to take over and walk you through the slides, and then we're certainly available to answer questions. Thank you very much.
Thank you, Mr. Enton. So let's advance to the next slide. This is a quick summary of how we've organized the presentation today. So first, we're going to talk about the industry response. Then we're going to cover the mortgage payment relief options that are out there. And some of this has been covered in previous presentations. So I'm going to really speed through some of these slides, but we are happy to answer any questions. And then we'll close out by looking at the foreclosure and eviction protections, which Mr. Enton just talked about. And again, happy to answer any questions. So let's advance to the next slide. So as Mr. Luby talked about, the success of a bank is inherently linked to the success of its clients and its community. And the Maryland banking industry has been incredibly proactive and consistently proactive in working with their clients, their residential mortgage borrowers, and their community throughout this pandemic. The MBA itself has been very proactive. One of the very first things we did was go out with a press release emphasizing, if you have any questions, any concern about your mortgage, about a stimulus payment, about your business loan, pick up the phone and call your banker. They are there to help. We've had weekly calls with our members. We are in constant contact with our fellow state and national banking associations, as well as our regulators. Of course, as the chairman said yourself, nothing is done in a vacuum. Everything is incredibly interconnected, and we make sure that we stay in close contact with both the Maryland Commissioner of Financial Regulation, but our federal regulators as well. And we are in close and constant contact with both our state and federal policymakers. And if we could advance to the next slide. We also established a landing page for COVID on MBA's website, and that will take you to links for all of our member banks. So if you have any constituents who find that a handy sort of one-stop shop, please feel free to refer them to that. Let's advance a slide. Again, the banking industry has been really proactive, and this slide drills down in some greater detail on the various tools that banks are using to work with their customers, ranging from loan payment deferrals to forbearance to interest rate reductions, fee waivers, increases in lines of credit as they are needed, consumer loans, consultation, and more. And I do want to pause and really recognize an important factor, and really one of the bright spots through this pandemic has been the incredible strength of the housing market right now. So not only is there, the banking industry has been incredibly proactive with these tools, but one of the things that has really helped is we have mortgage rates that are at historic lows and a housing market which is really hot. So one of the things that was a struggle during the housing market was people didn't have a lot of equity in their homes, and we're not seeing that in this instance. So people have been availing themselves, and our members have been recording record refinances, for example, which enables people to lower their amount of their mortgage rate and help out with other bills as well. So there's a lot going on here to help consumers. Let's advance to the next slide. So we've already spent some time talking about the foreclosure that the forbearance, resulting from the CARES Act that can be extended up to 360 days. And an important factor in here is just in caps at the bottom of this page, which is the FHFA's statement clarifying that no lump sum will be required at the end of the forbearance. There was some concern initially that there would sort of be a big payment due at the end, and that is clearly not the case. And I do want to point out at the bottom of these slides are references, web links that we intentionally embedded in this presentation so that if they are helpful to you in talking with your constituents, if they have any questions about where to find this information, you can use this as a resource. Let's please advance. In April, the Governor Hogan came out with a financial relief statement. We worked very closely with the governor's office on this, and it really highlights the things that the banking industry is doing to work with their customers. So let's move forward. Next slide, please. So in terms of the national forbearance statistics, the National Mortgage Bankers Association issues a weekly forbearance and call volume survey. And so what they reported is about 5.5% of the mortgages are currently in forbearance. Now, we've included on the slide some detail in terms of the second bullet with the 3 bullets under it on how they shake out by who holds that loan. So you'll see sort of the second bullet of the 3, the share of Fannie Mae and Freddie Mac forbearance is roughly like 3.3%. Now we've gotten questions about how are portfolio loans or how are they faring in comparison to the Fannie Mae? And as you can see here from the statistics, they're faring quite well. So just because your loan is not backed by Fannie or Freddie, the forbearance is being applied, and that's consistent with what our members have been telling us as well. So let's move forward a slide. If we can advance a slide, please. Turning to foreclosures, looking at the statistics, this is a drill down into Maryland itself. The delinquency rate for mortgages on residential properties in Maryland was 9.2%. So that is an increase. However, I need to emphasize that that statistic includes loans in forbearance. So notwithstanding the loans in forbearance, the delinquency rate is holding steady to what it was before the pandemic hit. And I think those statistics are quite important because it bears out how banks are working with their customers to make sure the relief is there. In terms of the percentage of loans in the foreclosure process, at the end of the quarter, it was below 1%. And again, that is consistent with where things were before. And before we entered the pandemic, we were already at historic lows for both delinquencies and foreclosures. Please advance a slide. We've talked about the federal protections in terms of the foreclosure moratorium, so I won't spend any more time on this slide. If we could advance. And then as Mr. Enton talked about, Governor Hogan has came out with an executive order in early April, which has been extended with some new aspects to it. So the Maryland's foreclosure prohibition has now been extended to the end of January 2021. So that foreclosure, the NOI portal has been completely closed for quite some time now and is accepting no new submissions. If we could advance a slide. So just here at the bottom of the slide, you'll see some links. And I do want to point out that the Federal Consumer Financial Protection Bureau has some really wonderful customer-facing videos and web links to help people identify if they're not sure who holds their mortgage. There's a lookup tool. There's some information on who they can contact. We always recommend your very first call should be your mortgage servicer, which is on your statement itself. But if there's any questions about mortgage forbearance, mortgage foreclosure, that is a great slide to refer to. And that wraps up our presentation. Thank you very much for the opportunity to be here and talk with you today.
All right, thank you very much. Mr. Enton, I think I see your hand waving there. Do you want to chime in again? Do you have come off of mute?
I could, thank you. Could you go, Mindy, could you go help them go back to the slide which details what's in the governor's December 27 order? Because I think that's critical information that we haven't supplied before. And I just want to call their attention to it. It was about 5 or 6 maybe slides from the end. if you go back, if you scroll forward or
Let me
keep
find
going,
it.
it was, you jumped ahead of that, and I just thought that was important.
Sure. So this is found on slide 9.
Keep going. Yeah,
If we could go to slide 9.
right here. Yeah. Extends forbearance. Right. Right. And then after, was there another slide like that, or was that was the slide?
No, this is it.
But once again, you can click on the link. I mean, like Mindy said, there are links there every place. You can click on that link, and the governor's order came out, and then a lot of questions were raised, and he issued the Commissioner of Financial Regulation issued FAQs to clarify a number of points, and the governor clarified even more points in a subsequent order. And we'd be happy to make sure that we get all that information to you. But it's very, very clear that Maryland has been amazingly proactive in making sure that borrowers are protected as we go through this. That's all I had to add. Thank you. I just wanted you to see that slide.
No, thank you. Much appreciated, Bob. Thank you very much. And Mindy, thank you for the presentation. And Ramon, congratulations. I know you're a resident of Maryland and Howard County, but it's never too late to move to District 20 in Montgomery County. So our door's always open. All right, next we'll move on to Rory and John. I see Rory there. Are you ready to go? You all queued up?
Yeah, Chairman Smith, we don't have a presentation, so we were just going to speak to a few issues. Don't want to repeat, especially given the timing. We don't want to repeat what has already been said. I think Mindy and Ramon and Bob did a good job covering the current resources that are out there through CFPB and Fannie and Freddie and the other groups. I just wanted to speak a little bit and give an update to the last when we were before the committee back early in the summer. And we were in the process of doing some research and just talk a little bit about what credit unions have done. We've talked a lot about folks being proactive and working through a variety of things. And, just back in the early data, and we're updating it and we'll get it to you. But, credit unions were reaching out to their members early on in the pandemic, especially to their mortgage holders. They were actually there's several credit unions that were picking up the phone and making thousands of phone calls to their actual account holders to specifically ask what types of support they needed, what kind of requirements they needed. We also, as an association, reached out, did a lot of press to let folks know that credit unions and banks were considered essential employees by the federal government, and that's why they were open. And thanks to the commissioner able to get on with the federal regulator to talk to both federally chartered credit unions that were chartered through the state to ensure that operations were open, that lobbies were open, and that there was consistency and that there wasn't any type of conflict between what was going on from a federal level and what was going on in the state level, to make sure that there was clarity with that. And in addition, there's a lot of credit unions, and I think this is important, that there's a lot of credit unions that may not have institutionally held mortgages. They may be actually holding those mortgages within their own portfolio. And all of those credit unions were following and continue to follow the CARES Act directives. And I think that's an important distinction to make, especially with credit unions being owned as not-for-profit financial cooperatives by their members, that they were also following those practices. We have virtually every credit union has provided that have been requested, have provided any type of fee waivers, deferments on loans, not just on the mortgage side, but also on the consumer side. So as Mindy, I believe, had mentioned, or Bob, that there haven't been any complaints with regards to mortgages from anyone here in the state of Maryland on the banking side. We're happy to say the same thing on the credit union side. We did have one complaint that came through with regards to a repossession order for an auto, but it turned out that it wasn't held by a credit union. It was by another financial institution. So that was encouraging as well. But I think the key, and I'd like to take a step back to what Mindy had said, and I think it was the Department of Building Association and the Maryland Multi-Housing Association. I think one of the key things that in talking with this committee and also being on other meetings and hearings throughout the last year, this issue of including institutions at the table when discussing these rules, discussing these programs, it's important to have that seat at the table so we can provide perspective, but also bring your perspective back to our members, because that's where that discussion really needs to flow and to go. Because sometimes I don't think that, you know, for instance, in the first few months of the pandemic, over $2 billion in loan relief was provided to consumers that were members of credit unions. And that was just in the first handful of months of the pandemic. And it's been a consistent and theme that we've heard as far as how credit unions can reach out to their members, making sure that they inform members of what they can do, especially from a forbearance. I think it's, as all of you know, credit unions aren't in the business of being realtors or trying to sell assets. So trying to keep people in their homes is of the most importance for a credit union. And then also helping them to find avenues that they can have as support. So working together, working at ways to find a solution that can keep people in their homes, but also keep financial institutions sound and safe and sound in their operations is also, it's a delicate balance, but one that we need to work on. And fortunately, thanks to the governor's office, the commissioner, and platforms like this, to have these dialogues are incredibly important. And we'll provide, Rory and I will get together, we'll provide some information back to the committee. We'll update these numbers, you know, whether it's the $2 billion in loan relief, the hundreds of thousands of consumers that have been helped with deferments, and those types of things. We'll continue to provide that information to the committee, but would continue to request the opportunity to have an opportunity to speak to what the credit unions are doing for their 2.2 million members here in the state of Maryland.
And then the only thing I'll add, kind of something that's tertiary to the mortgage issue itself. I was speaking with one of our lending officers at one of our member credit unions, and she was saying kind of the silver lining to this for a lot of folks, because they've had so many phone calls and one-on-ones with people going through tough times, was the amount of financial counseling and financial literacy training and education that's come out of this. You know, everybody, we've provided a lot of data and things on our websites, and so did the credit unions, that people can look to learn how to kind of manage their finances more. But, you know, in the time of crisis, obviously that becomes an issue that's up front in people's minds. So I think it's been a good opportunity. Well, I know it's been a good opportunity for a lot of our credit unions and their members to really kind of get down to brass tacks about financial literacy and financial counseling. So, you know, it's been tough times all around, but, you know, that was one thing that was very nice to hear. And lastly, I'll just say, I've been, you know, pleasantly surprised, not surprised, but really happy with the way our members have operated. Obviously, as we go back and forth, you in your positions as government leaders are doing your best to protect your constituents, and us in the credit union world are doing the best to protect our members. And everybody has kind of the same goals, but there's you know, just differences in how to get there. And our members have overwhelmingly just been open to help. You know, the answer to a lot of questions is always, hey, what do you think about this? And they say, well, it's not ideal, but, you know, we're here to help our members. Let's do what we have to do. And that's just been really good to see it, you know, moving forward as we make our way out of this thing. You know, we're just in a good position. I think, you know, I think that's something that the government and business leaders should all be pretty happy about, you know, kind of around the horn. So as John said, we always appreciate the ability to come out. And once we get all the results back from everybody of our most recent survey, when it comes to the data about mortgage foreclosures, et cetera, we'll get that to you.
No, Roy and John, really appreciate it. And I appreciate all the panelists today. Thank you for your time and your expertise and the information that you provided. I think it'll be very helpful for all of us as we move forward. We're now moving on to our Q&A session, our section of the presentation or the briefing. And then we'll follow that with a brief statement by the chair of the working group, Senator Hettleman. So I know that Senator West, you had the first question, and then Senator Wallstreicher is next in the queue. So Senator West, over to you.
Thank you, Mr. Chair. And thank you to all the panelists. This was very informative. I do have a couple of questions, most of them for Judge Morrissey. So thank you, Your Honor, for sticking around. First of all, I note that this is an area of law in which I've never practiced. So some of my questions may sound ill-informed. You said that, normally speaking, 55,000 eviction cases, failure to pay rent cases are filed each month. And then you went through a long series, read through a bunch of months for this past year in terms of how many cases of that type were filed during that month. There was one that struck me as being anomalous, but my fumble fingers couldn't get to the paper quickly enough to write it down. It was either July or August. It sounded like an extraordinarily high number of cases. Am I correct in that? Do you still have those numbers around?
I do have the numbers. So if we're talking about failure to pay rent, is that correct, Senator?
Yes.
Okay. In March, it was 33,000. So that's about 20,000 less than it normally would be.
Right.
In April, that's when we went down to phase 1, and we were only handling basically incarcerated individuals and domestic violence. And also the CARES Act had come in and created kind of a much broader defense than what the CDC order or the governor's order does. It dropped to 6,300 in April, then 3,700 in May, 2,100 in June. And then everyone, I think, started to realize that there was a time limit on the CARES Act, and it was going to expire at the end of July, I believe. I can't quite remember right now, but sometime in that time frame. So it rose to 6,800 in July, 16,000 in August, 30,000 in September, 33,000 in October. That's when we were in phase 5. And then November, we had to go from phase 5 down to phase 2, or we went to phase 3 for about a week and then realized we had to go to phase 2. And so it started to go down to 24,000 in November, but that was at the end of November when we did that.
Okay, so we, under normal circumstances, you get 55,000 a month, and then all years since March, including March, it's been far less than that. Some months far, far less than that. And do you have any idea whether these cases have simply gone away or whether they're sitting there in limbo waiting to be filed when an opportunity arises?
So at every opportunity, that's a great question, Senator, and it's kind of the $1 million question, if you would. At every opportunity I've had, I've encouraged landlords to dismiss whatever cases that they filed that are no longer valid. And that can occur for a majority, it can occur for a large number of filings. For example, if they were to have filed on the 5th and then the person pays them on the 6th, they're just going to dismiss the case. That's the way it works in the court. And that happens pre-pandemic on a very regular basis. 2/3 of the cases end up that way. It could be from payment. It could be that they were able to get themselves into some of these programs, which is, I hope, what was happening, because that's a win-win for everybody. It could be that they voluntarily moved to another location or they found another rental unit to rent. So I don't expect, even when we get fully out of this, that we'll go right back up to 55,000 again. I would expect a lot of the cases that already have been filed to have resolved themselves. In fact, our experience when we went from starting to go back up to full speed, although we never got there, the appearance rates of both landlords and tenants were in the low percentages, like teens or less. They just weren't showing up because the matter had been resolved one way or the other.
Good. Well, that's helpful. So along the same lines, I multiplied 55,000 per month times 12, and it came up to something in the range of 650,000 cases per year in a typical year. But then you said later on that the average number of evictions per year is 22,000. So can you explain what happens with 650,000 cases filed, but only 22,000 evictions?
So it's a multi-part process. There's the failure to pay rent, and we don't call it an eviction filing. We call it a failure to pay rent filing because that's what it is.
Right.
And that would be for whatever the amount is due. And it's not a judgment when we enter judgment, like a money judgment would be in regular court. It's a judgment for possession in that amount, meaning that if the tenant doesn't pay that amount, then the landlord can file the next set, which is a warrant or request for a warrant of restitution, which is the eviction proceeding then. But they have to certify to the court that they haven't received any payments, and then that that will eventually go over. If we agree that the warrant's appropriate, it goes over to the sheriff's office. Then the sheriff determines when and they're going to evict for the individuals. I suspect that the same thing that's happening now happened before, and that's that a lot of cases get paid in between the time. A tenant can pay up to the moment of eviction unless their right of redemption has been foreclosed, and that's they have to have 3 judgments against them in a 12-month period, 4 in Baltimore City. So a lot of times it doesn't even get to the warrant. I think if I remember the statistics correctly, about a third of the cases out of that 650,000 approximately have warrants filed in them. So 2/3 of them don't even get to the warrant stage.
Okay. Well, taking that information, let me jump then to Mr. Greenfield. Mr. Greenfield, so you've just heard that the vast majority of these cases pay up before the eviction occurs. 650,000 cases are wheedled down to 22,000. So during this pandemic period, once people fall into delinquency, have you seen a similarly large percentage of people who fall into delinquency paying up, or have you seen instead a lot of people not paying up and the amount due getting higher and higher and higher as the months go on?
Yeah, we're seeing, thank you for the question, Senator. We're seeing a higher and higher percentage of delinquent residents who owe multiple months of rent. We have surveyed that, and that is an issue on both sides, frankly, on the landlord and the tenant. And there's not much that we can do given where the posture of the district court to regain possession or so what we are doing is we're working actively with tenants like that, someone who's behind in multiple months, to try and get them rental assistance through one of the various programs.
Okay, helpful. And then finally, Mr. Shaw, turning to you, you talked about a bill, I think it's Senator Smith's bill, that would extend the eviction prohibition. And I'm paraphrasing what you said in your PowerPoint slide, but extend the prohibition to last until the end of the emergency. And then I wrote and through the economic recovery. So what does that mean? The emergency will come to an end when the governor repeals the order of emergency. But what do you mean by and through the economic recovery? Are we talking about an extra month or two, or a year, or 2 years, or 5 years? Can you answer that?
Well, this is a critical question, I think, for the committee and all legislators to consider, because the way this is played out is the governor has been on a monthly basis extending his determination that there's an emergency. And in the meantime, legislators haven't had their say about how long certain protections should actually last. So you're completely dependent on the executive to make that extremely crucial policy decision. Now, what we have to figure out, what you have to figure out as a policymaker is how long your constituents will need housing stability as a predicate to getting back on their feet, getting jobs, getting their kids back in school, so on and so forth. And what we've seen in different local jurisdictions with emergency provisions is that there's reliance on the executive's state of emergency order plus 90 days or plus 180 days after that, as I think some way of getting at this idea that the economic recovery will take a while, particularly for the segment of Maryland that we're talking about. Because like I was pointing out in my own chart, we're not really talking about the 75,000 and higher income bracket. We're talking about really an entrenchment of peril among $50,000 and less annual income. And so I think that's the challenge. I'm not an economist, and I think you might be able to talk to some, but figuring out how long this recovery will take is a challenge.
What
just
is
to wrap up,
if I could interrupt, what does your bill say about that? It certainly can't say until the economic recovery has concluded. That would be anybody's guess. So
yeah.
The bill must be more specific than that.
Well, yeah, not to be coy, I don't have the bill language as it was finally drafted. I think Delegate Janelle Wilkins and Senator Smith, Mr. Chairman, may be able to specifically point you to what was sent to drafting on their particular bill. But I think one of the emphases here is we want the legislators to decide, and then that should be the law of the land, so to speak, until the legislature meets again to decide the way forward. And I think that one way to do it is have a set date, such as the end of 2021 or the beginning of session, the next 2022, or you could set some metric, for instance, by unemployment rate or vaccination rate and what have you. But I think certainly one of the lessons learned during the pandemic is that certainty is a premium. You definitely want to have hard dates if you can get those.
Okay, I have one further question. I'm sorry, Mr. Chairman, for taking up so much time, but we do have about 10 witnesses. I have been storing up these questions. So one last one. Mr. Shaw, of the 2,547 evictions that you cited that had occurred between July and November of this past year, do you happen to know how many of those were filed pre-pandemic and how many of those were filed after the pandemic hit in March?
I don't have a way of knowing that. I don't think the judiciary could pull that number for us. My estimation would be that up until October, we're largely talking about cases filed right around February and March before the pandemic. But certainly those large spikes that you were pointing to, with 30,000 and more filings in September, October, those strike me as claims for rent due from the summertime. And I just base that on my own practice of my clients.
Great, thank you so much.
Got it. Thank you, Senator West. And to answer your question, I think the language, I don't have it before me, but as I remember, the language is probably silent on that issue on the amount of time. So that's something we would have to discuss during hearings. Vice Chair Wall Striker had to step aside for 1 second. So we will then skip over to, I see Senator Castley has a question. Senator Castley?
Sure. Can you hear me okay now?
We can, yes.
All right, good, thanks. Sorry, I had grandchildren all over the room before, so I didn't bother to video in. It was rather pandemonium here. So I want to, first of all, thank the Chief Judge for, I'm looking at these numbers. So before the pandemic hit, we were 55,000. I guess that was a month, right, Chief Judge Morrissey? 55,000 a month. And then when things really hit hard, we were down at 6,000 a month in filings, which is an awesome effort for the court to both get the information out and work with landlords, work with tenants, explain stuff. So I just find that number staggering in a great way. I mean, that the fact that folks were able to work that out and make that work, and that people were able to stay in houses and landlords were working together. I just find that highly commendable. I know that took, you were working with the governor's orders, with the federal law on that one, but a big part of it was the courts and what you all were doing. So, wow, what a success story. I also wanted to thank Mr. Hickey, who I don't know from previously with Baltimore County. I was also very encouraged by your county's I don't know, stewardly use of the CARES Act fund. I was very impressed by your numbers, sir, on the decision to use those for rental assistance. Looks like that's the overwhelming force of where you all decided to go with that. And I find that very interesting that when the county government, I always believe in you guys, that where the rubber meets the road, and when you were provided with resources, looks like your number one solution was rental assistance. So that was very interesting. And I did your criteria, and they're like, wow, that's, hats off. And then you're using some private folks to manage that. But that's great. And hopefully we can continue to work with you all and provide additional funding to support that effort to provide the rental assistance. What a great way forward. Unlike some of the other members of the committee, I actually sit in rent court. And I've been in rent courts mostly in Hartford, but in some other counties as well. And I know we're kind of talking about personal stories here. I just want to share you some of my personal stories that involve some of those 2,500 folks who Judge Morrissey's courts did issue evictions on. 3 of them I said, and we're not my case, but in one day, one afternoon docket in Harford County District Court, 3 cases ahead of mine, the evil, greedy landlords were the tenant's mother and grandparents. Those were the 3 cases. In each one of those cases, the parents were saying, or the grandparents were saying, look, I let him or her move into my basement to pay rent 9, 10, 11, 12 months ago, and told them to get a job. They've made no efforts, and I want them out of here. And quite frankly, the cases seem to be more fit for family law court, because I never saw so much crying and screaming and yelling in a landlord-tenant action. But there are those cases where you do have to move forward. I personally had 3 cases, none of which involved people in poverty or children or people with COVID. In each of those 3 cases, the tenants well knew what their legal rights were. They were simply staying beyond the term of the lease, and they had been advised well before the COVID that in each of these cases, the rental unit was a temporary deal, that it was supposed to go to the landlord's child, or with the landlord themselves in one case was supposed to occupy the property and had sold their house and was just simply waiting on the term of the lease to expire so they could move in. So I'm just one lawyer, and I'm seeing three cases personally that were not in any way offensive or involved putting people on the street with COVID of my own, plus 3 more where it's the grandparents. There's 6 for just one lawyer out of 2,500 in just one little area. So clearly there's a reason, and these aren't all evidence of reason for us to panic. The one thing that does cause me concern here is that I found something interesting sitting on this committee and watching the hearings in the various, not just our committee but others, and the realization over the last 7 years now that there's a strong public policy in this state, whether it's written or not, but it's pretty darn obvious that government housing doesn't work. Government housing, we tore down a lot of it in Baltimore City because it was rat infested. Women asking for government services were being bribed for sexual favors, and a lot of other nasty crap. And so what we're really looking for here is we're solving a lot of these problems with the rental market. And when I look at the spreadsheet, the charts put up by some of the presenters earlier, most of these folks are not big institutional landlords. They're actually well below 50%. I know in my own county, we don't have very many institutional landlords. It's mostly people renting that extra house, grandmom's house after she died, the one little rental house, that kind of stuff. They're not big institutional landlords. And so we're trying to encourage those people to stay in business, provide rental units for folks who mostly not wealthy people. That's pretty much the exception. If you got the money, you buy. Anybody knows that. And so I'm really concerned about the law of unintended consequences, and that we might do things that would mean that people should not be renting their house. And I can tell you about 3 homes that I've seen since this pandemic started that were pulled off the rental market simply because the landlord said, I can't deal with this stuff. We're not using this as a rental. We're going to pull it off. We're going to sell it. It's going to let somebody else deal with these headaches because the profit's not there. I'm carrying a mortgage. I have a tenant that's not paying. I can't risk this again. And we're pulling this off the rental market. So we do have to be really careful. And the law of unintended consequences here to me would be that we shift the dynamics of what we're doing here and actually reduce the availability of units rather than and we really kind of throw gasoline on the fire here rather than helping it. I think that with that said, I'm really one sort of a disconcerting part about this meeting here today is that there's nobody on this call right now representing those landlords. There isn't anybody on here who I consider to be a small landlord and who's providing the bulk of the rental units in this state, especially for those low income folks. I mean, obviously the high end market tends to be the institutional stuff, but I got a lot of folks in my county that just rent out that townhome that it's not the best. It's a decent townhome. The market went down a little bit on them, so they're going to rent it for 4 or 5 years. But once you change the dynamics, they're bugging out. They're going to sell it at a loss and beat feet. And I can give you addresses if you want, multiple people who pulled it off and decided to just stop playing the game here. It doesn't behoove them. Some you have to consider as we look for, and I hear Mr. Shaw talk about, we got to, let's sort of, don't let this crisis go to waste. Let's strike for institutional change. Look, a landlord, you got people here from the mortgage industry. The people in the mortgage industry, you're going through some tough times, but you're going to be okay because in the end, the equity's in the house. Unless you screwed up in the start, the equity's in the house. So you may take a slight hit, but the equity's in the house. On the landlord, for most of these kind of cases we're talking about, there is no equity in the house. The equity is what the tenant has put in the security deposit. The tenant security deposit is it. If you don't get that, you don't get anything. There is no money in the bank. There's no judgment to collect on. It's that security deposit. And that is why, folks, landlords go into court immediately. Because if you don't go into court immediately, the very minute the tenant is deficient, you're now going to spend the security deposit on the month that you try to give the tenant a grace period. So now that security got his bond. He was deficient in January. You didn't go into court. Now that money that you took for security deposit is now gone because you didn't get it in January. You waited till February because you were negotiating. Now you're 2 months behind. The max you will ever get out is the 1 month security deposit. And if we make it even more complicated, like we have for mortgages, and make it 3 or 4 months, the landlord's still going to ever only get 1 month of rent. That's it. There is no, you can't go after these people for judgments. This isn't like you're going for their insurance company. You've now hurt the market. You've punished small landlords who in many cases are taking, the rent is covering the mortgage and that's it. So we've got to be very careful in what we do here because we're dealing with a lot of small landlords by and large. I don't worry about the folks in the multi-housing industry. You do a great job, but quite frankly, I think you're well protected in what you're looking at. You've got the numbers to balance this as long as you can do a reasonable job. But if I'm a landlord with 1, maybe 2 houses, but most of them only have 1, I have no backup. That's it. I'm carrying a mortgage on 2 properties, one I'm living in and the rental unit, and I will never make up for the extra rent the mortgages I had to pay without rent. It's gone. That tenant is what we call in the industry judgment proof. So we got to be really careful here. I think when we're talking about rental assistance to landlords, rental assistance to tenants, that's awesome. But when you want to start talking about, let's make landlords do backflips and treat them. Look, these games work in the mortgage industry, again, because ultimately we jerk mortgage holders around, but eventually they're going to get paid because eventually the house is going to get sold. And in Maryland, for most cases, if they did their due diligence right, they're going to come up okay. They just extend it out a little bit. I'm not advocating for more screwing you guys over, but that's the reality. But for tenants, you don't. You can't, every time you delay them, it's out of their pocket. There is no equity to come after. So I just want to encourage us as we're looking forward, the call is sort of dominated by mortgage industry people here, and we're apples and orange. The other piece of the call is dominated by big landlords. It's apples and grapefruits. The real people here are the poor squash bananas, which are the small landlords who nobody's on this call representing, who ultimately, when we squeeze them hard enough, they're going out of business, and those critical rental units that we all rely upon are going to go away. So please be careful in what we do going forward. I think what we have right now is a carefully crafted balance that says, landlord, come into court right away. And the nice part of bringing into court right away is if it's the landlord's fault, the tenant can file to have the property repaired. They can put the money in. There's all kind of mechanisms in the legal system that says put the money in. And if the tenant puts, if it's a failure to pay, the services can be referred to and we can move forward. Being in court is not a bad thing. And we talk about taking the filing fees up to $150, like you were filing a circuit court action, to me is an utterly ludicrous proposal, because the landlord, that's almost half the rent in many of these cases. So the system we've got where we encourage landlords to go into court promptly is not a bad thing. And the suggestion that, oh gosh, they keep going into court, that's not to be feared here. That's a good thing. And the courts are used to that, and they're able to deal with it. And because you're in court, we hold landlords' feet to the fire. We keep the market honest. We can make sure that landlords provided he has to file a certificate showing he's had lead paint testing to even get into court. So we do a lot of things by getting these folks into court, and it's computerized, it's set up. So I just think some folks need to go sit in district court for a while and watch some landlord tenant cases. If you haven't spent a week or two sitting in district court, it would really help you coming into this term. It's tough now because they're not really holding many of them, but to actually see what's going on and how the system is really, it's not a bad system. It's not set up, it's not an evil system. And and the judges, by the way, in the district court are really good people. A lot of them are Democrats, which kind of offends me a bit, but they're really good people. And they really do pay attention to the needs of both the tenants who are in need, who are getting screwed over sometimes, and the landlords who are in need as well. And we have a system right now that says we hire good judges, we empower them, and we trust them to go out and do the right thing. And you can see by these filings that a lot of good stuff is happening. Judge Morrissey, again, thank you. And my commendation to you and to all those hardworking men and women sitting in your courtrooms day after day dealing with these issues. Thank you very much. So, Mr. Chair, I know that was kind of lengthy, but I think this is an important piece of the segment that's not being covered here are those individual landlords. Thank you.
Senator Kessler, I always appreciate, obviously, the one thing I appreciate about the committee is the diversity of opinion. And so, I appreciate it. So I think we're all better for it, even if we all don't agree on every single point. Next, I think we have, so thank you for that. Next, I think we have the Vice Chair, Wallstreicher. You're up next.
Thank you, Mr. Chairman. Thank you for your leadership on this. And thank you to Senator Heddleman for her chairmanship of this work group. My question is for Mr. Enton. I don't know if you want to pop back, Mr. Enton, and certainly Mindy and Ramon, if you want to chip in. At the end of her presentation, and Carissa, you can bring that back up, or Heather, you can bring that back up. Carissa made some recommendations as to perhaps codifying some of these things in law, but only for the duration of the emergency order. So Heather, I don't know if you can grab Carissa's presentation and just pick up those last few slides where she was making reference to the mortgage market. But Bob, I just wanted to get your opinion on those recommendations.
Well, I guess can you hear me okay?
Mm-hmm.
Yeah, I mean, the devil would be in the details. I've thought a lot about this. And, I think that if there was some evidence that the federal government and the governor's office weren't adequately dealing with the situation, and I don't believe there's any evidence to that effect whatsoever, quite the opposite. And if the industry wasn't stepping up and doing what it needed to do to deal with the situation, then yeah, I would think so. What would worry me would be to codify these things, and then whenever you guys go, you go home and you don't come back for, let's say, 6 or 9 months, and the situation changes, we're stuck. And once again, I don't think there's any evidence that the situation isn't being adequately dealt with. If there was, I guess I wouldn't, I try to make credible arguments when I talk to you all, and I would make my wife's bringing me a cup of coffee. Thank you. I would make that argument. I wouldn't make that argument, but that's what really kind of makes me nervous. And I can tell you that we weren't thrilled with the governor's order. There are some things that are in there that we don't like, and things that aren't in there we would like to have seen go in. But we're adjusting to it. We're dealing with it. It is what it is, and we just don't really see the need at this point, for legislation. So I think that would be something that we just don't think is necessary, Senator. With all
okay, thank you. Just a quick follow-up, just to provide a little more specificity. So I agree with you absolutely. You guys are doing a great job, and it's taken care of. forbearance is about a year, but we've seen this extremely delayed vaccine rollout. It's delayed because of the federal government, and then Maryland is at the bottom of the list when it comes to the speed at which the vaccine is coming out. And so people who took advantage of the full year's worth of forbearance may come up in March and not be vaccinated, or schools may not be back in session, and jobs may not have returned at that 365-day mark. And so they may run out of forbearance before everything comes back. And so I think what Carissa's idea is let's extend the forbearance, not until we're back in legislative session 2022, because I agree that that's too long and doesn't provide what you guys are looking for, but extend the forbearance only as long as the state of emergency is declared. So just curious now with that specificity, whether your thoughts on that are any different.
Well, I would look forward to discussing that with you, Mr. Vice Chairman. I do think that you have to keep in mind that even if, that number one, we're granting forbearances regardless, okay, of whether or not it's mandated by the federal government or the state government. It's in our best interest to grant a forbearance, number one. Number two, with the length of time it now takes in Maryland to go through a foreclosure proceeding, even if the foreclosure, if you are granted a forbearance, and let's say that forbearance, runs out, it's still, even if you institute the foreclosure proceeding, remember that no foreclosure proceedings could even be filed from April the 3rd until the end of this month. You couldn't even file one. So now they're going to take, and let's say I go through the whole thing with the forbearances, the borrower requests, and I look at it. No matter, for whatever reason, there's just nothing that can be done. We have no choice but to foreclose. Then it's still going to be a year and a half before I can get through the foreclosure proceeding. A year and a half. And all this time, not a single penny's being paid. The property's not being maintained. The thing that we've seen repeatedly, and the bills have gone through your committee for the last 5-6 years, is community groups, local governments coming in and saying, we need to speed up the foreclosure process. We have all these vacant and abandoned homes that are causing a blight in our neighborhood, and we can't do anything about it. Once again, I really don't think our foreclosure process is broken. It's stood the test of time. Most of these reforms that went in place when O'Malley was governor after 2007, with 3 different task forces to look at the law, and it seems to work pretty good. But I'm always available, and we'd be happy to talk with you more.
Excellent. Well, thank you, Vice Chair, and thank you, Mr. Enton. Are there any more questions? I'm looking around the Zoom room. Any questions? All right, I know that Senator Hettleman has one, but just real quick before she pops on, I just wanted a point of clarification. So, and maybe it's Chief Judge Morrissey or Mr. Shaw, you could help us out. So you had, I think, 115,000 failure to pay rent lawsuits were filed from July through November. I think I have that right. And then, so there were over 2,500, and maybe Ms. Hatfield, you can clarify, because I know it's a little bit more than that. 2,500 were evicted from July to November. And I just wanted a point of clarification, were most of those evictions initiated before the state of emergency or before the pandemic, or what was the status of the majority of those evictions?
Right. So we weren't setting any failure to pay rent cases starting March 16th until well into August. I believe at the end of August is when we started doing them again. So they would have had to have had a pending, they would have already had to have had a judgment, and then a writ of restitution would have been filed. I do agree with Mr. Shaw, probably starting it. So you file, you get into court usually within a week, there'd be a judgment. You have to wait 4 business days before you can file for a warrant of restitution. And then it takes the court however long to process that, another week. And then it goes over to the sheriffs, and then they do it. That's up to them how they do it. I've heard anecdotally that sometimes they just do it by zip code. If there's 5 properties in one zip code, they're going to go out and do those on a Monday. So it can be several weeks before the eviction actually occurs. So if they got a new judgment in August, well, in September, they probably wouldn't be able to start foreclosure, or start eviction until November. So there's probably about a 2-month lag, I would say, at a minimum. Does that help with?
It does. It does. This is notwithstanding the actual, the impact of an eviction during, in the midst of a crisis, but I just wanted to get clarification on the numbers. So.
Right. And what we don't track is these are the evictions for all case types, not just failure to pay rent. So if there were breach of leases that we were hearing during the emergency times, or tenants holding over, or wrongful detainers, those are grouped in. It's just, we just get a notice back from the sheriff that says they actually evicted.
Got it. Understood. Thank you very much. Okay, Senator Hedelman, I think you had a question.
I do. Thank you very much, Mr. Chairman. It looks like, and a couple of people have mentioned this in the hearing today, that the state of Maryland is likely to get over $400 million in rental assistance or housing, or that can go to any number of different eviction prevention programs, utilities, et cetera. So I'm curious, and I guess, Terry, if you could take a stab at it first, and then others chime in if they so desire. But how do you think that should be directed? It sounds like, is it rental assistance? Is it along the, would you expand your STEP program greatly? I'd be interested in hearing you're on the ground, hearing directly from tenants and landlords, obviously, but where would you put it?
Well, I think one of the overarching challenges is this work is all a bit of a funding alphabet soup of trying to figure out, how do you take your CDBG with your ESG and your CARES Act, and how do you blend it together into something that's going to time out properly, that's going to hit the need. Our CDBG money has significant hurdles built into it. And, I can only do 3 months with that program, but the next round from the state, I can do 6. In our STEP program, because it's CARES Act, I can go back 9 months and wipe out that debt, right? So I think the more flexibility you can build in to let the locals decide how they want to get the money out, with certain standardizations and protections, of course, built in. I think the locals have been forced to figure this out on their own anyway, and I think we should start to fuel that. We're taking a close look. Utilities are something that we're still deferring to our state-driven OHEP program, what they can handle, but we haven't really seen, we don't know what the ultimate scope of need is. So that makes it really difficult to figure out what tranches to put funding in which bucket. We've also been watching the homeownership piece, foreclosure, carefully, and there's been a lot of talk about that. What I would say more important even than what we're allowed to spend the money on is, for both the state and federal officials, being careful not to, with the best of intentions, include too many restrictions on this money as far as how specifically we need to dictate COVID impact. We've talked to other counties with certain funding sources who have had issues with a spouse dies of COVID, you've lost that income. However, the interpretation of that particular funding source was that might not count as a COVID impact because it wasn't you. That's one example where we really have to be careful. The other is, although it's well-intentioned, restrictions on the deals that the attachments that go into place if landlords accept this money to cover the tenant's rent. How many months do they need to go without taking further action? These are all active conversations that really need to be thoughtful and happen in due course. So local flexibility, as little restrictions on the tenants as possible, give us more flexibility to do this. And I would say it's going to sound like a very in the weeds thing, but a lot of this funding doesn't come with the ability for us to pass along operational costs. And so if we're bringing nonprofits or others who are spread thin and asking to help deliver this funds, which is incredibly difficult, we want them to bring on more caseworkers or things like that. And we have to have the flexibility to do that to a reasonable degree as well.
Mr. Hickey, thank you very much. Senator Hedelman, the floor is still yours unless you have another question, or you're good?
I'm good, unless Aaron's not muted. Did you want to comment on that?
No, I would just agree completely with Mr. Hickey. I though would place a very specific focus on rental assistance. I think that's the number one priority. I think that's where the large amount of money is needed. I think that's got to be the priority.
All right. Well, seeing no more questions, I'll just say this real quick. Thank you all to the panelists for your time, and thank you to the members of the committee. As Rory, I think you said it best earlier on, we've all got the same goal here, which is to keep people in their homes, whether it be rental or with their mortgages, and to keep people safe and see them safely on the other side of this pandemic. So look forward to working with each and every one of you in 9 short days during our legislative session. And with that, I'd like to say thank you again to the chair of the work group, Senator Heddleman, and turn over the floor to her to make some closing remarks.
Thank you so much, Mr. Chairman, and thank you very much for allowing us to have this opportunity today, just days before the General Assembly. It was actually 8 months to the day that you appointed the work group. So I just want to thank my colleagues, Vice Chair Waldstreicher, Senator Castley, Senator West, Senator Sidner, who put in a great deal of work, and Heather, of course, who staffed us all and put in a great deal of work over many months. In the late spring and early summer, we issued our report in July with a series of recommendations. Some folks, and thank you, Judge Morrissey, being the one and only who has actually responded in December as we requested to the recommendations for an updated status report. Really appreciate that. So we have 8 months of experience under our belts, all of us, and I know, have been reading about, talking to people, hearing from constituents who are quite stressed about their rent that is coming due. I know we've spent, as we should, time both on homeownership as well as rental, folks who are renting, but it seems like those who are renting are in the most precarious position right now, in the midst of a public health epidemic. And thousands of Marylanders have died from this virus. Thousands more have been infected and are dealing with the consequences. And while many people are suffering, many people are behind in their rent and are worried about when it will come due. Thank you so much to the wide array of stakeholders today who have presented, and we really appreciate the most up-to-date information. It will really help inform us 9 days from now as we go into session and consider so many of the different policy recommendations that many of my colleagues on this committee have put forward. And I just am very grateful for the opportunity to be working with my colleagues and many of you to advance good policy that will help to address these many really important and really stressful issues for so many of our constituents and so many of our fellow Marylanders. So thank you.
Thank you all very much. Have a good evening. Thanks.
Thank you.
Thank you.
Well said, Senator Edelman.